You're listening to an Airwave Media Podcast.
Hello, and thank you for joining the American Revolution. This week, episode 390, the 11th Amendment. Of the first 12 amendments proposed by James Madison, the 10 that were ratified mostly had to do with a restatement of the basic rights that all Americans already assumed they had. The two structural amendments, one involving specific rules on representation and another involving limits on congressional pay raises, both failed to receive enough state support to be ratified. On February 7, 1795, however, the states did ratify an 11th Amendment to the Constitution. The amendment read, "The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subject of any foreign state." That's a lot, but basically it's saying that states have sovereign immunity. This week we're going to take a look at why the young nation thought this amendment was so important. The Constitution itself, we all know, was a compromise document. The founders, even the men who worked on writing it together, did not agree on many issues and interpreted the final document differently. Most legal scholars at the time accepted the principle of sovereign immunity, that is, that a sovereign could not be sued in court. Now, this is a principle that came over from British common law tradition. In many medieval societies, kings were absolute rulers and their word was law. Over time, kings or other sovereign leaders developed rules for society and could make judgments about how those rules would apply in particular cases. Since kings couldn't be bothered to deal with every little dispute that a subject had, they appointed judges to make rulings in the king's name. In other words, judges hearing court cases were doing so in the name of the king, applying the king's rules to various legal disputes. In that context, it made sense that the king himself could never be sued in court, since the king would have to be judged by a representative of the king. Therefore, the king, as sovereign, was above the law and not subject to it. When the states became republics, they inherited this idea of sovereign immunity, holding that an individual could not sue the state in state court. The state, as sovereign, was immune from suit. If people had a dispute with something done by the government, the proper step would be to petition the legislature or the governor for relief, not the courts. With the creation of the U.S. Constitution, this raised an interesting legal question. The states gave up some sovereign authority to the federal government. Part of the purpose of the new federal court system was to sit in judgment of disputes between states. But what if a private citizen in one state had a dispute with another state government? Would federal courts be able to hear such a case, or would state governments still have immunity from suit? Alexander Hamilton, writing in the Federalist 51, insisted that the Constitution did nothing to impact the sovereignty of state governments against suits by private citizens. The text of the Constitution discussed states being parties to a case, but Hamilton insisted that language was so that states could bring suits, not that they would be subject to defending suits. Hamilton noted that sovereign immunity was a pretty fundamental common law doctrine, and that the Constitution said nothing explicitly to take away that traditional immunity from state governments. If courts had the power to give away tax money to claimants, then judges would essentially have the power to take over the legislative power of the purse. They could even drive states into bankruptcy. Sovereign immunity was a doctrine considered necessary to allow state governments to govern. And despite Hamilton's firm opinions on the matter, others disagreed. The doctrine of sovereign immunity put state governments above the law. They were not obliged to repay debts or be subject to any of the other normal rules that they imposed on others. During the Revolutionary War, states had issued a great many promissory notes to finance the war. They also seized a great deal of Loyalist property, which, under the terms of the peace treaty with Britain, they were legally obligated to pay compensation. The Constitution gave original jurisdiction to the Supreme Court for any cases where the state was a party. As I said, numerous scholars like Hamilton, but also James Madison and John Marshall, provided assurances that this only meant cases where a state brought suit. These leading legal minds assured skeptics that states could not be sued by individuals, even though the Constitution did not explicitly say that. Inevitably, lawyers would challenge those assurances. The first case brought before the court involved Dutch creditors who were suing Maryland for repayments of war debts. Maryland ended up settling that case before the immunity question was even raised. Another case that raised the issue began on October 31, 1777. The governor and the Executive Council of Georgia authorized the purchase of cloth and other military supplies from Robert Farquhar, a South Carolina merchant. The exact amount of the purchase is a little confusing since it's sometimes listed in continental dollars, sometimes in British pounds sterling, and sometimes in South Carolina pounds. As best I can tell, the value was a little over 7,500 British pounds sterling. That's really a lot of money when you consider the typical workman in that time period was lucky to earn 50 pounds a year. Georgia needed the supplies for the army. Under the terms of the agreement they made with Farquhar, he would deliver the goods by December 1st and would be paid in continental dollars. If dollars were unavailable, he would be paid the value of the debt in indigo. Farquhar delivered the goods ahead of schedule, but got no payment. Like most creditors, Farquhar regularly petitioned for repayment of the debt, but got nowhere. In 1784, Farquhar sailed from Charleston to Savannah, possibly to press his claim with the Georgia legislature. While he was aboard the ship, the boom swung wildly, knocking him into the water, resulting in his death by drowning. Farquhar left his estate to his daughter, who was 10 years old at the time. Alexander Chisholm became the executor of Farquhar's estate. Chisholm picked up the baton and continued to press Farquhar's claim for the repayment of debt that Georgia owed to him. In 1789, the legislature finally came to the conclusion that they'd already paid the money to their state agents, who should have given the money to Farquhar. If he didn't get it, then he needed to sue those agents, not the state. One of those agents was dead, and the other was apparently insolvent. Almost immediately after the federal courts were established in 1791, Chisholm sued Georgia for the repayment of this debt. He brought the suit in the Southern Circuit for Georgia and served the governor and the attorney general. Governor Edward Telfair answered the claim by denying that the federal court had any jurisdiction in the matter since Georgia was an independent and sovereign state. At the time, Supreme Court justices riding circuit heard such cases with the local federal judges. In this case, Supreme Court Justice James Iredell was riding circuit in Georgia. Iredell was from North Carolina. He'd been a prosecutor during the war, and during the debates on the Constitution, Iredell had been a leading advocate for ratification in North Carolina, a state which was one of the most hostile toward ratification. North Carolina ratified the Constitution after Washington had already appointed all of the Supreme Court justices, but one of those justices, Robert Harrison of Maryland, declined the appointment, leaving the first opening on the court. So Washington wanted to pick someone from North Carolina to welcome them into the Union, and he went with Iredell, also as a thanks for all of his work in getting the Constitution ratified. Iredell, along with the district court judge Nathan Pendleton, dismissed this case, accepting Georgia's assertion of sovereign immunity. Chisholm then appealed the matter to the Supreme Court and hired Attorney General Edmund Randolph to represent him. At the time, the Attorney General was allowed to take private cases as long as those cases didn't involve the federal government. The case was docketed for the 1792 term, but Georgia never showed up to argue the case. As a sovereign entity, the state believed it was not obligated in any way to show up or argue its case before a court that had no jurisdiction to hear the case. Randolph requested that the court render judgment, but the court decided to hold over the case until the 1793 term. Once again, Georgia did not show up to argue its case, but it did send a written protest to the court that the Supreme Court had no jurisdiction to hear a case against a sovereign state. This time, the court allowed the plaintiff to proceed with its case. Randolph made the obvious argument that the Constitution granted jurisdiction to, quote, controversies between a state and citizens of another state. There was no language that restricted this to cases where a state was the plaintiff. Randolph also noted that the Judiciary Act also gave jurisdiction to the court in cases where, quote, a state shall be a party. Again, there's no limiting language in the statute, just as there was none in the Constitution. Congress could have very easily said plaintiff instead of party if that's what it meant. Finally, Randolph noted that public policy required that states be held accountable to the law. One concern raised by the justices was how they might be able to force Georgia to comply with a ruling if they ruled in favor of Chisholm. Randolph simply responded that courts should not be afraid to render a decision that they deemed just simply because one party might act hostilely toward that decision. At the time, there were only 5 justices on the court. Justice Thomas Johnson had just resigned his appointment, and Washington had not yet appointed a replacement. John Jay was still the Chief Justice. One might think that part of the debate would be what was the original intent of those who wrote the language in the Constitution. But original intent really wasn't a thing at this time. One of the justices sitting on this case, James Wilson, had been at the convention and had played a role in writing the language regarding the court's jurisdiction. It's notable that, in his opinion, Wilson doesn't even bring up the question of what people at the convention were thinking when they wrote the parts on jurisdiction. This is true even though no other Supreme Court justice then or ever since then would have better knowledge of what happened at the convention. The 5 justices rendered their decision fairly quickly. At the time, it was the convention that each justice would write his own opinion. There were no majority or minority opinions, and justices did not simply join onto other opinions. It's probably no surprise that Justice Iredell, who ruled in favor of state sovereignty at the circuit court level, did so again in the Supreme Court decision. The other 4 justices ruled against Georgia. They ruled that the Constitution and the Judiciary Act both made clear that states could be parties to federal cases and therefore had removed any immunity that might exist under common law. Chief Justice Jay's opinion went further, arguing that the king's sovereign immunity transferred to the federal government upon ratification of the Constitution and that states were not entitled to any. Despite making the ruling that Georgia was subject to the court's jurisdiction, the justices also gave Georgia another opportunity to appear before the court. It scheduled another hearing for August of 1793, then another for February of 1794, and then another for February of 1795. In the meantime, Randolph began taking on more cases involving claimants against various states. One of the big ones was William Vassall, who lived in Boston until he fled in 1775. Vassall was a loyalist, and Massachusetts seized his property. He was seeking compensation based on the Treaty of Paris. For most Americans, however, the reaction to the decision in Chisholm v. Georgia was swift and hostile. Georgia continued its refusal to appear before the court. In November of 1793, the Georgia legislature passed a resolution declaring that anyone who attempted to enforce the court's judgment would be guilty of a felony and would be hanged without benefit of clergy. Massachusetts also took up this fight since it was facing this claim by Vassall before the court. Governor John Hancock called a special session of the legislature, calling the court's decision, quote, dangerous to the peace, safety, and independence of the states. The Massachusetts legislature declared that it would use the same strategy that Georgia had used and would refuse to appear before the court in the suit that Vassall had brought. This, by the way, would be Governor Hancock's last public appearance. He would die soon afterward. Virginia also passed resolutions that called the decision, quote, incompatible with and dangerous to the sovereignty of the individual states. Legislators claimed that this decision was an effort to consolidate the various republics into a single nation, something that they rejected signing up for when they ratified the Constitution. All the states had concerns over the fact that creditors who they had been blowing off for years now had a forum where they could collect those bills. Taxpayers would be on the hook and would not be happy about making all these payments. Congress wasted no time in responding to the criticism. The Supreme Court issued its original decision in Chisholm v. Georgia on February 18, 1793. On February 19th, Massachusetts Congressman Theodore Sedgwick introduced a proposed constitutional amendment prohibiting states from being called as defendants in federal court. The day after that, February 20th, Senator Caleb Strong, also from Massachusetts, submitted a similar amendment. Neither the House nor the Senate acted on these proposals since the term ended in early March, and there simply wasn't enough time to deal with them. The Senate debated Strong's proposed amendment, but it never got to a vote. The Third Congress did not meet until nearly a year later, in January of 1794. When it did, proponents were ready to act and act quickly. The Senate received a proposed amendment based on Senator Strong's amendment from the prior year. The new proposal read, "The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state." The main difference was adding the wording about the judicial power shall not be construed, rather than simply saying that the judiciary had no such power. This seemed to be aimed at the Supreme Court, essentially saying that their interpretation of the Constitution in Chisholm was simply wrong. Now, there was some debate on the actual language. Senator Albert Gallatin of Pennsylvania proposed a change that would have allowed suits that arose to enforce terms of foreign treaties. The argument for this was that international affairs was a federal power, and states should not have the ability to interfere with federal treaties by ignoring their obligations under them. Of course, the real-world application of this change would have allowed the federal courts to hear cases from loyalists who had had their property confiscated during the war because of the Treaty of Paris, and this would give them the right to bring these claims in court. This would have allowed Vassal's case against Massachusetts to go forward, even though that state was already up in arms at the idea of having to do that. The Senate overwhelmingly rejected Gallatin's proposed change. As I mentioned when we covered the Whiskey Rebellion, Gallatin would be kicked out of the Senate less than 2 months into the session. This was not related to his unpopular proposal. It was because the Senate determined that he had not been a U.S. citizen for the required 9 years, but Gallatin clearly was not making friends among his fellow senators when he did make this proposal. The amendment, as originally proposed, passed the Senate by a vote of 23-2, less than 2 weeks after its initial introduction. Following the passage in the Senate, the proposed amendment reached the House of Representatives. Debate there focused on the fact that people with a legitimate claim needed to have some form where they could seek compensation. There was a proposed change that would have restricted the jurisdiction of federal courts only in states where the states had failed to provide their own jurisdiction in their state court system. Once again, though, the overwhelming position of most representatives was that the federal government should not meddle in any way in how states handled their liability to suits. This proposed change was voted down overwhelmingly, and the House passed the amendment as written by the Senate on March 4th by an overwhelming vote of 81-9. Following congressional approval of the amendment, it went to the states for ratification. There were 15 states at the time, so 12 would be needed for the necessary 3/4 ratification. New York and Rhode Island legislators ratified the amendment in March, the same month that Congress approved the amendment. Over the course of the summer, Connecticut, New Hampshire, and Massachusetts ratified it. The delay in other states was primarily the fact that the legislatures in those states weren't in session at the time. But within a year, 12 states had ratified. The 12th state doing so was North Carolina in February of 1795. Despite the fact that 12 states had ratified, there was still a delay in making the ratification official. Several of the states that ratified the amendment failed to give official notice to Congress. So 2 years later, in 1797, Congress passed a resolution asking, by this time, President John Adams to inquire into the matter and get each state to provide their official notice. By this time, 1797, South Carolina also ratified the amendment, perhaps to make sure that the requisite number of votes were there, because by this time Tennessee had joined the Union as the 16th state. As a result of that, the required number of states for ratification had risen to 13, so South Carolina's ratification provided that 13th vote. As it turned out, the vote was not necessary. The various states reported that they had ratified the amendment before Tennessee joined the Union, so 12 were sufficient. In case you were wondering, New Jersey and Pennsylvania were the only 2 of the 15 not to ratify the amendment at the time. The formal proclamation of the amendment's ratification did not take place until February of 1798. As I mentioned, the court kept the Chisholm case on the docket in limbo during those 4 years because it was kind of waiting for formal word of the amendment. In the meantime, the parties brought another case against the states. One of these, Hollingsworth versus Virginia, The Supreme Court used that case to render a decision that the 11th Amendment applied retroactively to all cases, and that any case brought against a state must be dismissed. As a result of the amendment, the court dismissed Chisholm's case against Georgia. He would simply have to wait until the Georgia legislature felt like paying him back. Next week, we're going to cover the first big scandal of the Washington administration, as well as the resignation of President Washington's cabinet. Hey, thanks for joining the American Revolution Podcast After Show, part of the Airwave Media Network. Thanks to my Patreon supporters in the Alexander Hamilton Club, George Davis and Gordon Kemp. Thanks to Robert Morris Circle supporter Jason Guggens, and welcome to Maurice Morrissey, who has returned to support on Patreon as a standard bearer. I also want to give thanks to Frank Falkenstein, who gave a very generous one-time gift via Venmo, as well as to Lansky for a gift via PayPal. I really do appreciate everyone who continues to support this project by whatever means. It really makes it possible for me to continue. This week we covered the adoption of the 11th Amendment, which prevents people from suing state governments in federal court. Chisholm, who brought the case that resulted in the court decision that led to the amendment, would never collect any of the money owed to Farquhar's estate. In 1794, after the Supreme Court decision, Georgia ended up issuing 8 certificates, 7 of them for $1,000 each, and a third for the remainder of the amount owed. Even though this was 17 years after the debt, there was no interest or any other funds that would be offered. Now, these certificates were payable to the bearer, so they went to Farquhar's son-in-law, Peter Trezevant. The problem was that the state was never willing to cash in those certificates. Trezevant eventually sold 3 of these certificates. Whoever purchased them never tried to cash them in, and their whereabouts have been lost to history. Chisholm eventually died in 1810 with this debt still unpaid. But the story doesn't end there. Trezevant still held £5,000 worth of Georgia certificates. Trezevant and his family then moved to London. The family was not wealthy. Trezevant ended up getting a job as a bank clerk and got on with his life. In 1799, Georgia passed a new law proclaiming that any certificates not renewed within 2 years would be deemed fraudulent and forever barred. Trezevant was unaware of this law and didn't renew the certificates because he was off living in London. In 1808, Georgia also passed a law proclaiming that the state certificates would only be paid at 1/8 face value. They did this because, why not? It's not like the creditors could sue them in federal court. Despite these changes, Trezevant renewed his efforts to get paid what he was owed in 1838 when he petitioned the state senate once again. Now, this renewed effort may have been because his wife, who was Farquhar's daughter, had recently inherited a fortune from her grandfather, which allowed them the funds for another legal push against Georgia. At that point, the legislature appointed a commission to investigate the claims. The commission took 3 more years to reach a conclusion, but eventually recommended in favor of Trezevant's claims. It took another 2 years for the Senate to agree to a resolution to provide Trezevant with state bonds. Even at that point, the Georgia House rejected the claim. So it wasn't until December of 1847, 70 years after the initial debt was incurred, that Georgia finally agreed to repay part of that debt. In the lawsuit, Chisholm had sought interest and other damages. Georgia opted not to pay any of that. Instead, it agreed to pay the equivalent of 5,000 British pounds sterling, which at the time was about $22,222.22. There would be no interest on this 70-year delay for payment. Farquhar's daughter, who was only 7 years old when her father sold the materials to Georgia, had died in 1845, 2 years before Georgia finally agreed to this final settlement of the debt. Georgia did not pay all the money at once. It issued additional IOUs in the form of bonds. These allowed semi-annual payments over the next 10 years. At least these payments would be subject to 6% interest, and unlike the original IOUs, these were actually paid. But Trezevant would not live to see these final repayments. He died of old age in London in 1754. Of course, even that payment did not end the matter. Georgia, passed along the claim to the federal government for reimbursement under the federal law in which the federal government assumed state debts for the Revolutionary War. That repayment also took decades to collect and ended up being delayed by the Civil War. It wasn't until 1883, 106 years after the initial debt was incurred, that the federal government finally made good on its reimbursement to Georgia. A constitutional amendment relative to jurisdictional questions before the court may not sound very interesting, but at its heart, this was an issue about power. States were challenging the authority of the federal government over them, and the federal government was fighting to assert the authority that it believed it had according to the Constitution. There's actually a few instances where a constitutional amendment passed in order to overturn a decision of the Supreme Court. You can make an argument that the 14th Amendment, which was designed to overturn the 1857 case of Dred Scott v. Sanford, which essentially held that black people had no rights to citizenship. The 16th Amendment, authorizing the income tax, was passed after the Supreme Court struck down an earlier federal income tax law. And the 26th Amendment was passed after the Supreme Court ruled that Congress could not set a voting age of 18 for state and local elections. We have come to give the Supreme Court the final say over all interpretations of the U.S. Constitution. So when the Supreme Court does rule on a constitutional issue, the only real way to overturn that decision is through a constitutional amendment. My book recommendation this week is The First Chief Justice, John Jay and the Struggle of a New Nation by Mark Dillon. This book focuses on all Supreme Court cases that John Jay oversaw as Chief Justice, including, of course, Chisholm v. Georgia. The author of this book is an appellate judge in New York State. I think it's a great look at some of the court's earliest cases. If that sounds interesting to you, get The First Chief Justice, John Jay and the Struggle of a New Nation by Mark Dillon. My online recommendation is a link to the original Supreme Court decision in Chisholm v. Georgia. I did mention it in the main episode that cases from this era were a little different. It wasn't until Chief Justice John Marshall began presiding over the court in 1801 that the court began issuing a majority opinion and a dissent. This made the decision much clearer than the earlier method, where each of the justices just issued their own opinion, and you had to read all of them and figure out where the consensus was. When you read the opinions, Justice Iredell's actually appears first. Iredell, of course, was the one justice who ruled in favor of state sovereignty. The following four cases, of course, rule against it. These opinions, I think, are interesting not only for their reasoning, but also it's notable, as I mentioned again in the main episode, that justices relied on common law and other things. They did not focus on what happened at the Constitutional Convention or any other ideas of original intent, since most of them probably believes that they were founding fathers and their intent was original. As with all my online recommendations, I've of course included direct links to the case on my blog and in the show notes. My question this week asks, I heard you claim that the Battle of Camden had the most American casualties of any battle during the war. Didn't the Battle of Long Island have more? Well, the answer to this question is we don't really know. In both battles, American casualty counts were similar, about 900 to 1,000 killed or wounded, and another 1,000 or so captured. The records of battle casualties are counted differently by different historians based on often vague and contradictory records from the time, so assessing any count with any accuracy can be difficult. My best guess on my reading of many sources is that Camden had a slightly larger battle death count than Long Island. Part of this, I guess, can be based on what you count as a battle death. A number of deaths counted for the Battle of Long Island that may have occurred a short time later in the campaign. Also, many of those who died on the day of the battle in Long Island were not killed by the enemy. Rather, they fled into the East River and were drowned because they could not swim. I guess that still should count as a battle casualties, but they were not directly killed by the enemy. In terms of battle deaths, soldiers killed by the enemy and who died on that day, not wounded or dying days or weeks later, I think Camden edges out Long Island. The numbers are especially hard for Camden since there really aren't any good breakdowns between killed and wounded. My best guess is that there were probably 300 to 350 actual battle deaths, and I'm not even counting in that folks like General Horatio Gates who were mortally wounded in the battle but managed to live for several more days before they expired. At Long Island, credible death estimates I've seen range from around 250 to a little over 300. If these estimates are correct, and I emphasize that I'm not completely confident that they are, then Camden saw more battlefield deaths than Long Island. If you have a question you'd like me to answer, please reach out to me either via email or on X, Facebook, Quora, or Reddit. Well, that's all for this week. I hope you will join me again next week for another American Revolution podcast.